Hey guys, Aaron Dorr here with the American Firearms Association. If you love hearing about gun rights victories in court, you're going to love this video. Just last week in Illinois, Circuit Court Judge Scott Webb delivered an absolute beatdown to the state of Illinois and their FOID card requirements for possessing a firearm in your home. The case is State of Illinois versus Vivian Brown. I'm going to break the case down for you guys, give you the state's arguments, the judge's responses. His quotes are absolutely fire, and discuss kind of next steps and the current status of the FOID card requirement in Illinois. Before I do that, I just want to give a dose of encouragement, I guess, to gun owners who are currently in a blue state. I have lived in red states. I have lived in blue states. I know exactly how difficult, how painful, how enraging it is to watch these legal battles play out. It takes years to get a big victory in court. This case, as you're about to find out, has been going on for 8 years in a row. So it takes a long time. It takes a lot of money and a lot of effort and staying power to secure these victories. But I want you guys and gals to take heart. We have, as gun owners, secured more victories in court over the last 2 or 3 years than the last 2 or 3 decades combined because of the Bruen decision from 2022. So while it takes time, understand this. As gun owners, we are striking down gun control laws all over the country right now. This is just the latest example in a long line of victories. So don't lose heart. Don't give up. Maintain the fight. Now, this case, again, Illinois versus Vivian Brown, was a circuit court decision. So in Illinois, there is the circuit court, there's the appellate court, and the state Supreme Court. This case, again, circuit court, but it was heard twice before, oddly enough, in the state Supreme Court. In both of those cases, though, the court never actually interacted with the constitutional arguments that were raised in this case. They gave procedural answers to procedural challenges and ordered the case sent back down to lower courts to be re-examined. That's how Judge Scott Webb got this case. The case begins from a situation that took place in 2017. Like I said, takes a lot of time. In this case, Ms. Brown's husband, for some unknown reason, called 911, and he said, "My wife has just fired her .22 rifle in our bedroom." The police arrived, did a full investigation, found no evidence to support that claim, talked to other people in the home. None of them heard anything. They left the scene, did not take the gun, no charges filed, case closed. They filed a report and called it quits. But leave it to Illinois, right? So the state's attorney's office at the county level, days later, filed criminal charges against Vivian Brown because she possessed that bolt-action .22 rifle without a FOID card. Now, if you're not sure what I'm talking about, in Illinois, there is a FOID card requirement to possess any firearms. So any gun owner, regardless of age, any gun, handgun, long gun, rifle, shotguns, whatever, you have to have a FOID card to possess any firearm in the state. Separate from that is the CCL permit. This is a concealed carry license. This is the requirement to carry concealed. So FOID card to possess, CCL license to carry. Vivian Brown did not have either of those. So then, therefore, she was charged with this crime. It's important to note that Vivian Brown had no other criminal background of any kind. She was not prohibited. She's not a felon, no domestic violence, no protective orders. Her only crime, again, in air quotes, was not having a FOID card while possessing a .22 rifle in her own home. Illinois Code 65/2, subsection A, subsection 1 says, "No person may acquire or possess any firearm, stun gun, or taser within this state without having in his or her possession a firearms owner's identification card, FOID card, previously issued in his or her name by the state of Illinois." So that was the law that she was charged under. Now, Brown's lawsuit was very simple, 2 parts. Number one, it is unconstitutional to require me to have a freaking FOID card to possess a gun in my own home. And number two, charging me a fee of $10 to exercise a constitutional right is also unconstitutional. So from here's where Bruen gets involved, because prior to Bruen in 2022, the courts examined gun cases like this in a 2-pronged test. Number one, first prong, is the conduct covered in the situation? Is this conduct covered by the Second Amendment? If the conduct in question was outside the Second Amendment, case closed, you lose, go home. If it is covered, then you go on to the next prong. And the next prong, again, prior to Bruen, was, is there a compelling governmental interest to continue to restrict the behavior anyway? And no big surprise to gun owners, almost every lawsuit brought after the Heller case in 2008 and McDonald in 2010, we lost because the judges, very liberal, they would always say, yeah, this is covered conduct, but the government has a right to regulate this anyway. So literally almost every federal court battle fought in the days after Heller and McDonald, we as gun owners lost because the government could simply say, we have a compelling interest to regulate this conduct. Those days are gone. The Bruen decision 2022 replaced that second prong with a different prong. And what it said is, if the conduct is covered, if the first prong has been met, for the government to get this law, to have this law remain in effect, they have to show historical analog, historical traditions in this country's history at the time of the Second Amendment to justify this gun control law being constitutional. What does that mean? Very simple. If you want to have a FOID card requirement in Illinois, you have to show how in America's history, people were required to have a permit or a license from the government to possess a firearm. And of course, there is no such precedent. And so that historical analog is why so many victories have been notched in court by gun owners over the last couple of years. So the state, of course, commies to the end, argued viciously that this law met the Bruen standard in court. Number one, they said the Bruen case actually endorses our licensing scheme, endorses the FOID card. The judge laughed this argument out of court. He said, no, Bruen was all about New York State's licensing laws when it comes to carrying concealed. The FOID card in Illinois, Vivian Brown's case, was all about a requirement to possess a permit just to own the gun in your own home. So that argument was kicked out in court very aggressively. From there, the state tried to say that Vivian Brown, her conduct was not covered by the Second Amendment. They literally said that Bruen said that the people covered by the Second Amendment have to be law-abiding citizens. Well, because Vivian Brown is a criminal by not having a FOID card to possess a .22, she's a criminal and she is therefore not protected by the Second Amendment. The implications of that are massive, and the judge gave a great quote. It's a little bit long, 3 paragraphs. You got to hear it. You're going to love it. The judge, again, this is Judge Scott Webb. He says the state reasoned that because the defendant failed to apply for and obtain a FOID card and possess a firearm anyway, that she is not law-abiding, and thus she falls outside of the protections of the Second Amendment. But that reasoning would exclude every person who fails or refuses to comply with even the most draconian gun control laws from challenging their constitutionality because they would no longer be considered a law-abiding citizen. So, for example, if Illinois ever passes a mental health mandate to buy a gun, which is being talked about right now in various blue states, the court was being told by Illinois, well, then if they don't follow that, they're illegal. And if they're a criminal, then they can't challenge our law. It's a nasty bit of tyranny. He goes on and says they would then be considered to fall outside the scope of the people protected by the Second Amendment. This logic would open the floodgates for the government to pass the most restrictive gun control laws imaginable while severely limiting the number of people who could challenge them. Such reason is a fatally flawed attempt to make everyone criminals who refuses to bow their knee to the dictates of the government and kiss its signet ring. I mean, you can see the smoke rising off of Judge Webb's keyboard as he wrote this. So from there, the state's like, well, we got screwed here. So then the state says, fine, one last Hail Mary. There is historical precedent to what we're trying to do. And this is hard to even verbalize or hard to even imagine, but what these commies are doing, whether it's in Washington State, whether it's in New York, whether it's in California, or whether it's in Illinois, is they are trotting out examples from 100 years ago where the government said that black people could not possess firearms. And they're holding these examples up in court with a straight face, trying to use them to justify these current gun control laws. Judge Webb, again, blistered the state for their arguments. He says, the FOID Card Act is relatively recent vintage, only enacted in 1967. Frankly, there is no historical analog to this act. However, the state points to several disarming laws that focused on groups of people who were considered dangerous at that time. Many of these laws would be viewed as repugnant today as they were racist in their nature. This court regrets that those laws ever existed in the history of our nation. However, those laws were categorically different than that of the FOID Act. So what he's saying here is that's racist BS. But even if you want to use that as the basis of your justification, Illinois, you're wrong. And he says, first, those laws sought to disarm gun owners as groups of people who were considered dangerous. The very use of the term dangerous connotes that those individuals once possessed a right to bear arms and the government took it away. In other words, the individual had a right to possess firearms, but they did something to lose that right or were deemed mentally disabled. But that is not the case with respect to the FOID Act. Under the FOID Act, nobody has a right to possess firearms in this state unless and until they obtain a license first. Everyone in Illinois is prohibited from possessing a firearm, irrespective of their criminal background. Quite frankly, it is asinine. This is the judge, not me. This is the judge. Quite frankly, it is asinine to think that in the land of the free and the home of the brave, one must petition the government and pay a fee to be able to enjoy the fundamental constitutional right to protect oneself inside of one's own home. Whew. So again, you can see the smoke rising from Judge Webb's keyboard. His whole point here is very simple. To require us to get government permission to possess a firearm in our own home has no basis in the Constitution and no basis in America's history. Now, from there, the argument was about the fees. The state of Illinois says this is okay to require a fee. We have fee requirements for someone to exercise their First Amendment, for example. And the example they gave was when someone has to get a permit from the city to hold a public event. Maybe it's a protest, maybe it's a parade, whatever it is, you have to get a permit from the city. Judge Webb again smashes that and says, we're not talking about public events. This act, FOID Card, governs the right to possess a gun in our own homes, in their private spaces. And the analogy he gave is voting from home. After all, the left wants all of us to vote from home, mail-in balloting, right? And so Judge Webb says, do we require people to pay to vote from home? Of course not. He says, in fact, in Illinois, we even prepay the return envelope, their postage for the return envelope. And so there's no way to say the straight face that other rights are that we have to pay to exercise other rights. So this is a 15-page long blistering rebuke of Illinois' FOID law requirements. Now, couple questions. First of all, you're asking us, is the FOID law still in effect? The answer is yes. This case was limited to Vivian Brown. So if you're in Illinois right now, you still have to abide by the FOID requirements. So number two, if you're saying, then why do I care? Well, I'm going to give you again the reason why you should care. We are on a progressive path here as gun owners, whether it's in Illinois or any other blue state right now. These laws are coming down. I don't know when. I have no idea when. But there's going to be a day in the not too distant future when I believe the entire FOID law requirement in Illinois is coming down, because there's no way that a requirement to possess a permit just to have a gun in your own home, there's no way where that survives the Bruen challenge. There's just no way. So we have to get more cases like this one up in the chain to appeal these cases high enough up to secure these victories. For now, though, again, the FOID law remains in effect, at least for everybody else other than Vivian Brown in Illinois. So from here, this case will be appealed, probably already has been appealed to the appellate courts. From there, it will be appealed almost assuredly to the state Supreme Court. From there, it could be appealed, likely will be appealed to the United States Supreme Court. So again, we're in this progression and it takes time. But I want you guys to know, again, we are making real big strides as gun owners right now in court. We got to keep going. We got to keep fighting and keep notching these victories. That's all I have time for right now, guys. Do me a favor. Follow me on X at Real Aaron Dorr and share this video online to make sure everyone has the great news out of Illinois. Take care. Hey guys, ILFA is fighting like hell to hold the line here in Springfield to make sure our children's children still have a right to keep and bear arms. Get involved in this fight today. First, follow us on X. Second, sign up for text alerts from us. And finally, like and subscribe for more content.